I'm trying, thank you.
Good morning, everybody. Let's see. We are on live streaming. Okay. Good morning, everybody, and welcome to the Office of Tax Appeals. Today's oral hearing proceedings in the appeal of David Templeton is publicly viewable, and a stenographer will report everything that is said. I am Shireen Ridenauer and will be the lead administrative law judge for purposes of this hearing. I did not receive a list of case names and legal authorities that will be presented today by either party. Therefore, I am guessing neither party will be using such information that was not provided. Is that correct, Mr. Cristobal?
That's correct.
All right, is that correct, Ms. Jackson? Ms. Jackson?
Yes, that is correct.
Okay, thank you. All right. I am Shireen right now. Ms. Jackson, can you still hear me? Because I can't see you, so I don't know if you've been.
I can still hear you.
Okay. My name is Shireen Ridenauer, and I'm the lead administrative law judge for purposes of this hearing. Also present is our stenographer, Ms. Alonzo, who's reporting this hearing verbatim. To ensure that we have an accurate record, we ask that everyone speaks clearly, loudly, and one at a time. When needed, the stenographer or I will interrupt to ensure proper transcription. After the hearing, the stenographer will produce the official hearing transcript, which will be available on OTA's website. As a reminder, OTA is not a court, but is an independent appeals body, which is staffed by tax experts and is independent of FTB. While OTA is not a court, we must nevertheless follow certain guidelines to ensure that we establish proper record on which a decision may be based and to conduct an orderly hearing. All parties must be courteous to each other and may not interrupt another party. Each party will have the opportunity to be heard, so please wait for it when it's your turn to present your side. Also, I may interrupt the hearing if we get out of order or become counterproductive, as keeping us on track and creating a clean and efficient hearing record is part of my role as lead administrative judge. Do the parties intend, pending a showing of good cause, to submit additional exhibits not previously listed in the exhibit index or witnesses not previously identified? Mr. Cristobal?
No, Judge.
Thank you. Ms. Jackson?
No, Judge.
Okay. Are there any questions about anything I've said before we go on the record? Mr. Cristobal?
No.
Ms. Jackson?
No.
Okay. Ms. Alonzo, are you ready to proceed? Thank you. We are now opening the record in the Office of Tax Appeals oral hearing for the appeal of David Templeton, OTA case number 241017647. Today's date is July 15th, 2025, and the time is 9:40 a.m. The hearing is being conducted virtually with the agreement of the parties. This appeal is being heard and decided by a single administrative law judge under OTA small case program. My name is Shireen Ridenauer, and I'll be conducting the hearing, reviewing the evidence, and reaching a determination in this appeal. For the record, will the parties please state your names and who you represent, starting with the representatives for appellant.
Robin LaBrie Jackson for David Templeton.
Mr. Templeton, can you please introduce yourself?
And I am David Templeton.
Thank you. And for FTB?
Good morning. Leo Cristobal representing Franchise Tax Board.
Good morning. Alyssa Pinerbossi, also representing the Franchise Tax Board.
Great. Thank you, everybody. As stated in my minutes and orders dated June 12, 2025, there's one issue in this appeal. Whether appellant's claim for refund for the 2019 tax year is barred by the statute of limitation. The exhibits are listed in the exhibit log, which has been distributed to the parties. During the pre-hearing conference, FTB raised no objections to appellant's exhibits 1 through 6, and they were admitted into evidence. Since the pre-hearing conference, appellant has submitted exhibits 7 and 8. FTB, do you have any objection to appellant's exhibits 7 and 8?
No, we do not.
Appellants Exhibits 7A and 8 are also hereby admitted into evidence. During the pre-hearing conference, appellant raised no objections to FTB's Exhibits A and B, and they were admitted into evidence. As for witnesses, FTB previously indicated it will not call any witnesses. Appellant indicated he will be testifying today, and FTB raised no objection. As such, Mr. Templeton will be sworn in today before appellant's presentations, and there are no other witnesses today. As a reminder to the parties, during the pre-hearing conference, we decided that appellant will have 10 minutes to make his presentation, followed by FTB will have 10 minutes as well. Then appellant will have 5 minutes to provide closing arguments if he so choose. Each party is encouraged to monitor their own time. Does anyone have any questions before we move on to presentation? Ms. Jackson?
No.
Mr. Cristobal?
No.
Okay, thank you. Before we proceed, Mr. Templeton, I need to place you under oath so that your statements can be considered as testimony, and you will remain under oath until the close of this hearing. Will you please raise your right hand? Do you solemnly swear or affirm to tell the truth, the whole truth, and nothing but the truth? Please say yes or no.
Yes.
Okay, thank you very much. The time is currently 9:43, and when you're ready, Ms. Jackson, please begin your presentation.
On behalf of David Templeton, I think there are a few issues that were involved in the timeline to submit the amended return and the request for refund. Mr. Templeton was not notified until 2022 that there was even an issue with a tax year. With a tax return. And that notification came from the IRS, letting him know that there was the qualified business income deduction was not allowed because Schedule C's were missing from his tax return. As a layperson, he didn't quite understand why, what was missing and why. He tried to get a hold of the tax preparer who, during COVID year, so the 2019 tax return was to be filed in 2020, of which it ended up being filed late by the tax preparer, even though he entered into an agreement prior or before the deadline. The tax preparer didn't prepare it until later. Obviously due to COVID. Because of COVID, she retired. During this time, Mr. Templeton was going through a contemptuous divorce and a move because of that divorce, and didn't have paperwork, couldn't find paperwork, and was dealing with a spouse who wasn't cooperative. And it took him time to gather the information to figure out what exactly the problem was. The tax preparer that took over from his tax preparer did not have any records and was not given any records. That tax preparer was Knutson, Curry and Associates. That is Exhibit 4, his engagement letter with that tax preparer who no longer was in business. When Mr. Templeton was notified that there was a problem with the return, that is when he started his process of trying to gather the correct information, working with the prior tax returns replacement and the uncooperative X. When he found me in 2024 and was gathering all of his information, we had difficulty as well trying to understand what the prior tax preparer had even done. Therefore, the timeliness of being able to submit anything was out of his control and was not his intent to be untimely. It was not something that or something that we do feel was reasonable cause for the delay. As Exhibit 5, the notice from the IRS came on February 14th of 22, and that is when it specifically, that Mr. Templeton was specifically notified that the Form 8995 was being disallowed because of the lack of information, meaning the Schedule C. But he didn't know what that was until we started working together. Therefore, we feel that the refund should be allowed and penalties removed for untimely filing.
Thank you. Mr. Templeton, did you want to say anything as a witness?
Not at this time.
Okay, thank you. I do not have any questions at this time. FTB, the time is 9:48, and when you're ready, Mr. Cristobal, please begin your presentation.
Okay, thank you, Judge. Good morning. Like I mentioned, my name is Leo Cristobal, and I represent Respondent Franchise Tax Board. This appeal is for tax year 2019, and as mentioned, the issue in this case is whether appellant's claim for refund is barred by the statute of limitations. 2019 tax returns were due on April 15, 2020. Appellant did not file a 2019 tax return until December 16, 2020. Consequently, as it relates to the statute of limitations, the last day for appellant to file a timely refund claim under the 4-year statute of limitations was 4 years from the original due date. In other words, the last day for appellant to file a timely claim for refund was April 15, 2024. Here, appellant did not file his claim for refund by this date. Accordingly, respondent denied the refund claim. Appellant has presented various extenuating circumstances and reasonable cause arguments as an explanation for why his claim for refund was received after the expiration of the statute of limitations. Unfortunately, refunds can only be granted to taxpayers as permitted by the statute of limitations, and the explicit and strict language of the statute of limitations provides that there is no waiver of the statutory period based on reasonable cause. The fixed deadline may appear harsh, but it is understood that the clarity that is provided by the statute of limitations promotes fairness and practicality in the overall administration of income tax policy. So here, notwithstanding any delay by the IRS, a former tax preparer, or the COVID-19 pandemic, appellant's claim for refund was not received by April 15, 2024. Therefore, appellant's claim was untimely, and under California law, respondent properly denied the claim based on the claim being barred by the statute of limitations. In conclusion, because appellant did not file a claim for refund on or before the last day prescribed by the statute of limitations, the claim is time barred, and FTB's action denying appellant's refund claim should be sustained. Thank you, and I'm happy to answer any questions you may have.
Thank you. Mr. Cristobal, by reading the briefing, I think there may be some misunderstanding regarding the COVID extension to July 15th, 2020, and that impact, if any, on the 4-year claim for refund deadline. Could you please expand on that, please?
Yes, Judge. So is it all right if I mention statutes or any prior cases in this moment? I know I didn't submit.
Yes, you were not anticipating this question. Please proceed. It's fine.
Yes. So according to federal and state laws and regulations regarding postponements and the effect of postponements on due dates, the short of it is that postponements due to disasters like COVID-19 don't affect the original due dates of tax returns. And so as it relates to the interplay here, the original due date of a 2019 tax return was April 15th, 2020. And even with the COVID postponement, it didn't change the original due date. And the law is clear, and there has been an OTA presidential case that has addressed this exact issue. It's the case of Nguyen. It was decided in March of this year, where the OTA did make it clear that the COVID postponement did not change the original due date of a 2019 tax return.
Thank you very much for clarifying on the record. I appreciate that, Mr. Cristobal. Ms. Jackson, you may make a response to FTB's arguments or further address any questions, or Mr. Templeton, you can make your witness testimony, but neither is required. Would you like to make closing remarks, Ms. Jackson?
I think that the FTB just answered the question that I had, which is the COVID extension would have extended the filing period. But it seems like the court precedents did not change that date.
Hence the reason why I asked it, for the clarification on the record. Is there anything else you would like to say in closing, or Mr. Templeton, would you like a chance to speak?
Robin, did you have anything else?
No, I didn't have anything else. The
Okay.
extenuating circumstances I felt were valid, but that does seem like the FTB statute of limitations did not change even because of COVID.
Mr. Templeton, ask you, did you want to speak and say anything?
I not really. I mean, I would say what's important here. And, you know, I'm a law-abiding, tax-paying citizen. Those 3 or 4 years during COVID were difficult, and I understand that the law is the law. And I just hope that there's some, you know, ability of this group to see that. And, you know, I mean, I have a claim with the state. I have a much larger claim with the IRS, and I hope that, you know, it's fulfilled. So that's all.
Thank you very much for your testimony. And FTB, did you have any questions for Mr. Templeton as a witness?
No, we do not.
Okay, thank you. I want to thank everybody for participating in today's hearing. I am now concluding the hearing. The record is now closed, and I will issue a written opinion of OTA's decision within 100 days from today. Today's hearing in the appeal of David Templeton is now closed.